and then has the audacity to come here and say we are the ones obstructing justice. This is the most unprofessional conduct I have seen in a long time.
Welcome to Rebel Chaser. My name is Gail, and I have a clip for you from another new judge for my channel. His name is Judge Daniel Coursey, and he is at the DeKalb County Superior Court in Georgia. I have to kind of lay out the case. The case is about the death of an 18-month-old child who the defendant was babysitting. The child died of a drug overdose, and the defendant has her own child, who is now 6 years old. But at the time of the death, the child was 4. The state, or the judge, I'm not really sure, wants a forensic interview of that child. And that is what they are discussing in this hearing. But there's all kinds of accusations flying between these two attorneys. The prosecutor is accusing the defense attorney of obstruction, and the defense attorney is accusing the prosecutor of lying to the court. Let me know what you guys think about this one.
State versus Leandria Pierre Louis. Everybody ready?
Yes, Judge.
Yes, Your Honor. And Ms. Pierre-Louis is here on Zoom, and I think also present, Judge, is there's an attorney now for the child who is the subject of this motion. So that child has their own lawyer. And I believe Ms. Katie Hingerty, who's the attorney for the child, is also present.
That's correct, Your Honor. I'm here.
Okay. How old is this child?
He's 6 years old, Judge.
And he's I guess, a witness in the case, Your Honor. He's not the victim, or certainly not the defendant. But he's not the victim. The child is not a victim in the case, according to the state. He's a witness.
Okay. Well, my question is, why can't y'all just agree on a date and time?
Well, Judge, the state's been trying to do that, and Mr. Apt, at this point, quite honestly, from the state's perspective, is actively obstructing this interview from taking place. I've provided Your Honor with a couple of emails as attachments to my motion. Mr. Apt is suggesting that this forensic interview take place at his office. I think that Your Honor is well aware, as well as Mr. Apt should be well aware, that forensic interviews have certain protocols and standards, and they do not take place at defense attorneys' places of practice of law. They take place at the locations that are meant for the interviews to take place, that have children-friendly rooms. They take place at Children's Healthcare of Atlanta and the Georgia Center for Child Advocacy. Judge, the state has gone above and beyond to ensure that this interview takes place in accordance with Judge Morris's orders, and Mr. Apt is preventing that from happening.
May I respond, Your Honor?
Yes, sir.
So just a little history, Your Honor. The court may be aware or may not. I am lead counsel in an actual trial that's ongoing called the YSL trial in Fulton County. We're in the middle of trial. It's a year-long trial. So it takes up a tremendous amount of my time. The state gave me less than 1 day's notice to make the child available for an interview. And at the time they scheduled that forensic interview, not only was I in trial, but also I don't know where the child is located. In order for my client to get bond, my client had to go from jail back to her own home. And as per the court's instruction, my client could not, who's an adult, could not have contact with her own child until a forensic interview took place. So that child had to be removed from the residence and was. And I don't know what family member has that child. I don't know where the child is residing. But I told Ms. Caldwell that I would make a good faith effort to locate the child and arrange an interview, but I couldn't do it on one day's notice. Now, there's a little more background. Your Honor, I attached an exhibit to our response to the motion this morning, which I sent to your assistant, and it was received. That is an email from Judge Morris. And why is that important, Your Honor? Because in all the emails and exhibits that Ms. Caldwell attached to her motion, she neglected to include that email. That email was sent by Judge Morris to both Ms. Caldwell and myself on November 14th, instructing the following, and I'm going to read from it. The forensic interview needs to be conducted within the next 10 calendar days by Saturday, November 25th. If the interview is not conducted by November 25th, the child will be reunited with the defendant. So what did Ms. Caldwell do in response to that email and instructions from the judge? She did a couple things. First, she removed that language that the judge put in an email to both of us from a proposed order that she then submitted to the judge ex parte. Now, I've only been doing this job 29 years. I've been in front of Your Honor many, many times. In my almost 30 years of practicing law, I have never removed language that a judge instructed me to put in an order and then submitted an order and not copied the defense counsel on that order so that they wouldn't see that that language had been removed. This is highly unethical and unprofessional behavior by Ms. Caldwell. She is changing the court's orders. She is not copying defense counsel on those orders. She is altering the language and instructions from Judge Morris, and then has the audacity to come here and say we are the ones obstructing justice. This is the most unprofessional conduct I have seen in a long time. If I, as a defense lawyer, and Your Honor, I've been in front of you many times, if you were to instruct me to put language in an order and then I removed that language from the order and I didn't show my opposing counsel, I would be held in contempt. This is so egregious. I had to call, and I'm not the kind of person that runs to the bar or the court on this kind of stuff. I just don't do that. But I did call Ms. Caldwell's supervisor because I wanted them to be aware that this type of unprofessional behavior was taking place. This is egregious. The judge instructed us that if the child were not interviewed, the child would be returned to the parent within 10 days. And Ms. Caldwell removed that language from the court order and then didn't tell us about it. And we made a very reasonable, very accommodating offer to have the child interviewed. By the way, Your Honor, this is not a typical forensic interview where, in a child victim crime, there needs to be a forensic interview like in a sex crime. This child is just a witness in the case, and the witness is 6 years old. And Judge, I'm not even sure I understand the law with respect to whether a witness can be compelled to waive, a 6-year-old witness can be compelled to waive their Fifth Amendment right to remain silent and forced to be given an interview with the state, or waive their Sixth Amendment right to have an attorney present. So now I don't represent the child. I don't represent the person who has custody of the child. I represent my client, who's the defendant in this case. It is not my job to make that child available because I don't know where the child is. And Ms. Caldwell wants to blame me for obstructing the courts, but I don't have custody of that child. My client doesn't have custody of that child. We don't even know where the child is. So for Ms. Caldwell to suggest that I'm obstructing is ridiculous because I don't know where the child is to make it available. Now, this child has their own lawyer, and I would imagine that lawyer is not going to allow that child to waive its Fifth Amendment and Sixth Amendment rights and be forensically interviewed ex parte by the state as a witness in a case without that child's lawyer being present or their legal guardian being present. Their legal guardian has a right to be present if that child's going to be interviewed as a witness. And so does their lawyer. They have a Sixth Amendment right to have counsel present. And I am offended by the conduct of Ms. Caldwell in lying to the court, removing language, which is in an email to both of us that the court instructed, and then not copying me on the order. And I've been doing this for 30 years. I've never once submitted a court order to a judge and then not copied opposing counsel on it. And so for Ms. Caldwell to have the audacity to come into court now and say that I'm obstructing is the most ironic and sad thing I've seen, because this is highly unethical behavior on her part. Thank you.
Your Honor, if I could have an opportunity to
All
respond,
right, go ahead.
since I have just been lambasted by Mr. Apt. So if Your Honor will take a look at the email that Judge Morris wrote to us, there's nowhere in that order or the email that is directing me to put that language into a bond order. If there were, I would have put it in there. My job as a prosecutor is to be truthful and to be honest. I take that job incredibly serious. I'm an officer of the court, and I am likewise offended that Mr. Apt is sitting here putting information in front of the court that is just not true. The email that got started with Judge Morris was sent by defense counsel. They submitted a proposed order in response to me trying to find more information from them to submit an appropriate order to Judge Morris. The state had some concerns about the logistics of the conditions that Judge Morris imposed, because as her order reads, and I'm sure Your Honor has read it, she's not to have any contact with her own biological child until that child submits to a forensic interview. However, that forensic interview must take place within 10 days. So given that there was a Thanksgiving holiday coming up, the state asked if we could extend that timeline, because after we spoke with the Georgia Center for Child Advocacy and CHOA, they were unsure if they were going to be able to get the child in for that quick of an interview. And so Judge Morris's response was that she was not going to extend the time frame, and that if the interview did not take place within 10 days, that the child would be reunited with the mother. And nowhere in that email does it direct the state to put that information in the bond order. The bond order is worded as Judge Morris ordered in court. So nowhere am I lying. Nowhere am I omitting information that I was instructed to put forth to the court. And that's just not the case. As for the allegation that I am behaving improperly by submitting this bond order without first showing defense counsel, Judge, I know that you have been back here since we've been on Odyssey, and this is something that is routinely done. The orders have to be submitted through the Odyssey queue for the judges to sign them, and it is just not a thing that most of us do to email the court with an attached order in advance of putting that order into the queue. So there was no ill intent there, certainly, knowing that my order that I submitted was going to be given to Mr. Apt at some point anyways. There was absolutely no ill intent. Since we have been operating on Odyssey, it is the fastest way to just get things into the queue, and that is what took place here.
All right. Well, let me hear from Ms. Hingerty.
Good morning, Your Honor. Can everybody hear me okay?
I can.
Yeah, I don't want to interject into the squabbles going on between defense counsel and state. I am here to represent the minor child who, as we've said, is 6 years old. During the alleged incident, the child was 4. Now, I have a 5-year-old, Your Honor. You know, what the state is fishing for or hoping to obtain from a forensic interview of a child from events that took place a year and a half ago. I mean, my daughter can't remember meeting Santa Claus last year. So they're withholding this child from his mother. If I'm looking at the best interest of the child standard, you know, I do know where the child is. I know who's looking after the child. I've been in contact with that person. The child wishes to be reunited with his mother. And in fact, between the alleged incident, for over a year, the child was in his mother's custody and care. He's in public school in Gwinnett in a great school system. In fact, it was the school system I grew up in. He's going to He's in first grade in an elementary school in Gwinnett and would wind up going to the same high school that I went to. Those teachers are amazing. They're wonderful. There's been no allegation that the child has had any sort of trouble at home. Trust me, those teachers would have turned him in. There is no sort of open CPS or DFACS investigation going on with this child. So at this point in time, the child is living with a family member slash, family friend to be close to his school and to try and continue on to his life as normally as possible, waiting to be put into a forensic interview where they want to obtain God knows what from a 6-year-old and trying to obtain information from a year and a half ago. I would object to the interview in its entirety, just based on the fact that I don't believe it's in the best interest of the child. That being said, if the court does order that we go to the forensic interview, I do have the location and whereabouts and contact information for the child, Your Honor. But we would object, and I would also ask that I be allowed into the interview as his representative, should the court order us to go.
All right, Ms. Caldwell.
Yes, Judge. I mean, so Ms. Hingerty, I know that you were not present at the bond hearing that took place with Ms. Pierre Lewis, but this is not the state didn't. This is Judge Morris who has imposed this condition. The state is not asking, is not withholding the child from his mother. That's simply not the case. Judge Morris inquired as to why a forensic interview had not been conducted. And we had attempted to have a forensic interview done prior to the bond hearing that took place. We told Judge Morris that, and her response was to order the child to submit to a forensic interview, and obviously in conjunction with the other orders, special conditions on that bond order. Judge, this is a witness to a murder. And we do believe that it is appropriate for the child to be forensically interviewed. Judge, you've sat on enough murder cases at this point to know how this will play out at trial. The defense is going to get up there and say that this witness was in the room. Where's the interview of the witness? Judge, we are doing everything that we can to seek justice in this case. And this is part of it. So we would ask that the child be made available for a forensic interview. And as to Ms. Hingerty's request that she be allowed to come into the room with the child, that is not part of the protocol for the forensic interviews, Judge. And so we would object to that. We are simply trying to get truthful information from this child. And I do believe that the standard protocols of forensic interviews should be followed in accordance with that.
Your Honor, can I respond to all that?
All right.
Okay, so first of all, the state wants to have a 6-year-old child who's a witness interviewed without their lawyer. I mean, this person's a witness. This is not a sex crime case where the child's the victim. They're a witness, and now the state wants to deprive them of counsel. It's just preposterous. The other thing I think that is important is Ms. Caldwell is saying that the judge never instructed that language from an email to be put in a court order. The entire reason why the judge emailed us is because there was a dispute over what language should go in the court order between Ms. Caldwell and myself. And the judge responded and said, here's what I want. And then Ms. Caldwell took that language out, submitted a court order without copying us. Her excuse to that is, oh, well, we have an Odyssey system. But I've been practicing law here in DeKalb County. My office is in DeKalb County. I only do criminal law, and I've been doing it for 29 years. And I can tell you, I deal with a lot of assistant DAs in DeKalb County over the last 3 decades. And never once, not once in 30 years, almost 30 years, have I had a prosecutor fail to email me a copy of a proposed order. She can submit it through Odyssey and still send me a courtesy copy. She didn't do that. And the reason she didn't do it is because she knew she was removing language that the judge had instructed us in an email to put in. She can come up with all the excuses she wants, but it is reprehensible, irresponsible, and unprofessional behavior. And if that language had been in the court order, we wouldn't have to have had this emergency motion. And now she's suggesting that a witness in the case shouldn't have a lawyer or have a lawyer present while being interrogated by the state. I mean, that's in the Constitution, Your Honor. And I think it makes the entirety of this motion ridiculous. Thank you.
Your Honor, if I may. Again, I don't want to get in between the arguments going on between defense counsel and the state. I'm here to look out for the best interest of the child. We have a 6-year-old being with from his mom. And, you know, all of that being said, the family is doing the best they can to make sure that his life goes on as normal, that he's getting to school. He is doing well. He is in a public elementary school. And Your Honor, just to give you some context, I don't have full discovery in the case. I'm working on getting that information, but my understanding of the contention, you know, the state says it's a murder. The mother of the child was babysitting or watching along with her mother, another 18-month-old child who was in the home. That child died overnight. I think that my client was in the home at the time that the child died. It was not like somebody got stabbed or shot. The allegation is that the child had overdosed on some drugs. They thoroughly searched my client's home to make sure that it was a safe place to be. And then they determined that he should stay with his mother, and did, and successfully did, for well over a year. Like I said, there's no open defects case. It's not like the state has ever been concerned about his welfare. So if we're down to that, if we're down to looking at the best interests of the child and just taking a look at what is right for him, Your Honor, that is what I care about. He is 6. It is the Thanksgiving Christmas holiday. If the court orders us into a forensic interview, I can't stop that. However, I would ask to be present since he is a witness in the case and not a subject of the investigation itself. I would ask to be given reasonable time to do that. And all of this other stuff is not really my concern, Judge. My concern is the welfare of the minor.
And
All right. Here's what I'm going to do. I'll say that Ms. Ingerty can be present with the child during the interview. The interview will take place at CHOA, or the Georgia Center for Children. And we need to agree on a specific date and time. And it's supposed to, according to the bond order, it's supposed to be done by this Friday.
yes, Judge.
Just a minute. I would think y'all could set it up Friday, because I'm sure school is out on Friday. And I imagine CHOA and Georgia Center for Children, they got something going on then. So might be a little too quick for them, but I don't know. But Ms. Hingerty knows where the child is, and she can arrange all that.
Yes, Judge. So just to be clear, for when I draft this order, are all other conditions, except for this modification as ordered by Judge Morris, to stay in effect?
Yes.
I would appreciate it if Ms. Caldwell would send me a courtesy copy of the proposed order. Thank you.
Okay. You can do that, Ms. Caldwell.
Yes, Judge. Thank you.
So you think you can set it up Friday?
Judge, as soon as we finish here, I'm going to get in touch with CHOA and the Georgia Center. But what I will say, Judge, is that we had to, Mr. Chase, who is my superior, had to pull some strings to get the forensic interview that we did set up, that the child did not appear at. And I don't know if an interview slot is available for Friday, but I will give this court my word. I'm going to do everything I can to get that set up.
Well, my guess is it's not going to be a very long interview anyway, because a 6-year-old child who was 4 at the time is, probably not going to have a lot to say.
Yes, Judge.
And the Georgia Center for Children, it's just matter of getting the interviewer over there, ain't it? Thanksgiving may be a problem because people may be gone for Thanksgiving holiday and all that stuff. But
I was
anyway,
gonna put my contact information in the chat. Do you have that contact information? Because I'm for whatever reason, I don't see you in the chat as available to message.
I think I can find your email. I'll send you an email.
okay. All right. Anything else? I'm not going to get involved in all the accusations back and forth.
That's it from the state, Judge.
That's all from the defense, Your Honor. Thank you.
All right. Thank you. Do the best you can.
So the state is trying to figure out where the child was exposed to the drugs, how the child ingested them. And they didn't really say in this hearing what the drugs were, but I assume it was probably fentanyl, but I don't know. They searched this defendant's home, the babysitter's home, and found absolutely nothing. Now, you know, she could have hid them, she could have gotten rid of them, she could have flushed them. That's all a possibility. Or was the child exposed when he was with his mother, you know, prior to going to the babysitter's house? That's a possibility too. So I think that's what they're trying to figure out. And, you know, I don't know why they need to do an interview of this 6-year-old child, because like his attorney said, he doesn't remember what happened 2 years ago. He doesn't know. And, you know, he probably doesn't know. So anyway, let me know what you guys think. Thank you guys so very much for watching my channel, and I will see you next time.